Research Case Study, Week 2. New York Times versus Sullivan. Elected official Sullivan brought suit against New York Times, alleging that he had been labeled by advertisement in their newspaper. The advertisement included statements, some of which were false, about police action allegedly directed against students who participated in civil rights demonstrations and against a leader of the civil rights movement. Sullivan felt his reputation was being damaged by the New York Times publications entitled Heed Their Rising Voices. In the advertisement, it described the actions that were taking place in Alabama as students were engaged in nonviolent demonstrations in a positive affirmation. However, of the 10 paragraphs of text, the third and a portion of the sixth were the basis of Mr. Sullivan's claim of libel. They were statements of how truckloads of police armed with shotguns and tear gas ringed the college campus and even padlocked the dining hall in an attempt to starve them in submission. It went on to state again and again, the Southern violators have answered Dr. King's peaceful protests with intimidation and violence. They have bombed his home, almost killing his wife and child. They have assaulted his person. They have arrested him 7 times for speeding, loitering, and similar offenses. And now they have charged him with perjury, a felony under which they can imprison him for 10 years. Sullivan contended that even though they did not mention his name, the word police referred to him as the Montgomery commissioner who supervised the police department. Sullivan must prove, liberious per se, that the statements that were made of and concerning him. The jury must be convinced of malice in the sense of actual intent to harm or gross negligence and recklessness. The U.S. Supreme Court decision affirmed the Circuit Court of the Montgomery County award of $500,000 in damages. It held that where the words published tend to injure a person labeled by them in his reputation, profession, trade, or business, or charge him with an indictable offense, or tend to bring the individual into public contempt, they are liberious per se, that the matter complained of is under the above doctrine. Liberious per se, it was published of the concerning the plaintiff, and it is actionable without proof of precursory injury, such injury being implied. Gertz versus Robert Welch. Petitioner Eric Gertz was hired by the family of a murdered youth as counsel, during which time American Opinion, a monthly outlet for views of John Birch Society, published an article under the title A Frame-Up, Robert Newco and the War on the Police. The managing editor at the time was Robert Welch. Eric Gertz, being a private person and not a public figure, was portrayed as a big Irish cop, that he had been an official of Marx's League for Industrial Democracy. It labeled him as Linux in a communist frontier. It also stated that Gertz had been an officer of the National Lawyers Guild. None of the facts were true or were sustained by Robert Welch. These allegations affected Gertz's reputation greatly as a lawyer in Chicago. With the allegations told by Welch, it could affect his current and future client list. The trust that he had built for many years will be gone on the basis of lies. Welch's biggest mistake was not validating the facts. It's okay to have an opinion. Everyone has one. However, if you choose to voice yours in such a public display, make sure your facts are true and you have proof to back them up. In Ohio, the same defamation laws are the same as most states. They still use the Gertz versus Welch as a basis when deciding cases. I could relate to both cases. In our field, we will have to defend our clients in many ways. This information we learned will help us when fighting against bad publicity and allegations against our client's reputation.